The stats say that 1 out of every 4 accidents now on the highways involve distracted driving, which includes texting. We get a lot of questions from readers and clients and potential clients about what to do after they've been involved in an accident with the driver who was texting. So we'll answer some of those questions today. First question is texting while driving in fact illegal? And the answer to that is yes, it is. It's a violation of the New York State Vehicle and Traffic Law to send text messages or receive text messages, emails, photographs, or surf the web while driving. That makes sense. The punishment for that is a fine under the Vehicle and Traffic Law. And the real sort of implication for the criminal part of this is that if you are hit by someone who's texting while driving and they plead guilty to the Vehicle and Traffic Law offense, you can then use that against them in any kind of an underlying civil personal injury case. So the disposition of that plea can be very critical. One of the next questions that we receive is, am I able to get cell phone records of the person who was driving the other car? That's actually easier said than done, but it can happen in the context of a lawsuit, at which point we would demand that the driver send us copies of any of their records and also send us printouts of any communications and calls made at or about the time of the accident or on the day of the accident. We can also serve a subpoena on the cell phone carrier, which can sometimes be difficult to enforce and to get compliance with, but which we will ultimately get the records that we need. The other thing that we occasionally do in terms of cell phone records is that we will send what's known as a preservation letter to the driver of the other vehicle shortly after being retained. What we do with this letter is we say to the driver, we're representing the victim of this accident. We hereby demand that you preserve any messages that are on your phone and the phone itself relating to the time of the accident. Now what this does is this makes it so that if the driver deletes the messages or loses the phone or gives the phone away, you are now in a position to say that he has spoliated the evidence or has done away with the evidence or destroyed the evidence. And that can have a very serious implication in the personal injury case that follows. So we always send the spoliation preservation letter just to protect our client's interests. Another question that we often receive is whether insurance coverage will apply if someone is texting while driving. Every car on the road, for the most part, has some form of liability insurance to cover the driver in the event that the driver gets in a car accident. I guess it makes sense to ask the question of, well, if somebody's doing something illegal like texting while driving, is the insurance company still going to cover that claim, or are they going to disclaim or deny coverage? From what we've seen, insurance companies are continuing to recognize the claims and to pay the claims where there is merit. It's sort of similar to the situation where someone is speeding. Speeding is also a violation of the law, but insurance companies still cover claims when one of their insureds injures somebody else as a result of having driven too fast. There are some exceptions to this, but in the context of texting while driving, it is very likely that insurance would apply. Then the issue becomes whether there are sufficient policy limits or sufficient coverage to make you whole after you've suffered an injury. If you have questions about texting while driving, or if you've been the victim of a person who was texting while driving, please feel free to give us a call. We're always happy to help, and we're always happy to answer any questions that you have.